and welcome back. You're listening to Passing the Baton. I'm Jared Haidt from Tracktown Law, a virtual law firm based in Eugene, Oregon, offering flat fee estate planning and small business services across Oregon and Idaho. My goal with this podcast is simple: to take the complexity out of legal planning and make it something real people can understand and act on without the jargon, the guesswork, or the games. Today, we're talking about HIPAA authorizations, a document that tends to fly under the radar in estate planning, but quietly plays a major role when it counts. If the Advance Directive is about who makes your medical decisions, the HIPAA authorization is about who can even get information about what's going on. Before we get started, the usual disclaimer. I'm a licensed attorney in Oregon and Idaho, but listening to this podcast doesn't create an attorney-client relationship. Nothing here should be taken as specific legal advice. For that, you'll want to sit down with someone who understands your particular situation. And one quick reminder, if you'd rather read than listen, or want to share this episode with someone who needs it, you'll find a full write-up over at tracktownlaw.com. Every episode has a companion blog post that lays it all out clearly in writing. Let's set the stage. Imagine a medical crisis. You're unconscious, in surgery, or under heavy sedation. You have someone you trust at the hospital, maybe your spouse, your adult child, or a close friend, trying to figure out what's happening. They want to talk to the doctor, get test results, understand the plan. And they're told, sorry, we can't share that information without written authorization. That's HIPAA in action, the Health Insurance Portability and Accountability Act. It's a federal law that protects the privacy of your medical records, which is good, but without the HIPAA release form that names the right people, it can also shut down communication exactly when your loved ones need it most. This is especially critical in Oregon, where our Advance Directive form does not automatically give your representative the right to access your protected health information under federal HIPAA rules. A lot of people assume it does. It doesn't. It only authorizes them to make decisions. If you want that person, or anyone else, to actually receive information from your medical providers, you need a separate HIPAA authorization. And this isn't just about end-of-life situations. A HIPAA release can come into play anytime you're temporarily incapacitated or unable to handle your own affairs. Car accident, stroke, complication from surgery, even a short hospital stay while you're groggy or out of it. Without this document, your spouse might be sitting in the waiting room getting stonewalled by the front desk because the clinic's policy is no info without a signed release. It can get even messier when you have a blended family or more than one adult child. Let's say your kids are trying to coordinate your care, but one hospital won't release records to the others. Or you have a partner you've lived with for years, but you're not legally married, and they can't get a doctor to talk to them because they're not next of kin. Or you name a trustee or agent in your estate plan, but they can't verify your condition because the hospital won't confirm whether you're even a patient. That kind of delay can stall financial decisions, interrupt bill payments, and create chaos at a time when clarity is needed most. A HIPAA authorization solves this. It lets you name exactly who can receive your medical information and what kind of information they can receive. You can authorize just your primary care provider or all treating physicians. You can allow release of general records, mental health records, substance abuse treatment info, or exclude those if you prefer. The scope of the disclosure is up to you. It's completely customizable, but the key is it has to exist before the crisis hits. Now here's the thing. A HIPAA authorization doesn't give anyone the power to make decisions. That's what the Advance Directive is for. The HIPAA release just gets them in the loop. Think of it as a key that unlocks the door to your medical chart so long as you've granted access to the relevant records. When I draft an estate plan, I never assume a client will remember to ask for this. I include a HIPAA authorization in every single flat fee package I create. No extra charge, no optional add-on, it's foundational. Because without access to information, even the best drafted legal documents can get tangled up in real-world delays. Let me also clear up one common point of confusion. Sometimes people say, but I signed something at my doctor's office once. Isn't that enough? Probably not. Most medical offices have you sign a HIPAA form for their specific clinic only. That document typically covers how they can share your information within their own system. It doesn't give your representative or family access across hospitals, providers, or emergency settings. What you need is a standalone HIPAA authorization, one that's part of your estate plan and can be presented to any provider anywhere if something happens. It's also worth updating this form every few years. Typically, HIPAA authorizations don't expire unless you say they do, but in practice, some healthcare providers hesitate to accept older documents. I generally recommend refreshing them when you update the rest of your plan, especially if you've changed providers, changed relationships, or moved to a new state. The good news? Once it's done, it's easy to distribute. I always encourage clients to keep digital and physical copies of their HIPAA authorization. One in your estate binder, one scanned to your phone, one emailed to your named representative or agents. If it's hard to find, it might as well not exist. Now, let's talk briefly about who to name. You're not limited to just one person. You can name a primary and several alternates. You can authorize multiple people to receive information at the same time. For example, some clients want both their adult children to stay informed, even if only one is the legal decision maker. Others want a spouse, a sibling, and a longtime friend on the list. That's completely fine. The document can accommodate that. The only limit is that the people you name must be people you trust to handle sensitive health information appropriately. Once you give someone access to your records, they can see everything: diagnosis, treatment, medications, test results. That's the point, but it also means this isn't a casual decision. So what's the takeaway? Estate planning isn't just about where your money goes when you die, it's also about how you're treated while you're alive, and access to your medical information is a critical part of that picture. A well-crafted HIPAA authorization ensures that your loved ones aren't shut out when you need them most. It keeps communication open, it avoids roadblocks, and it lets your agents act with full awareness instead of flying blind. That's why it's not optional in my practice. If you're building an estate plan with Tracktown Law, the HIPAA authorization is included, period, because without it, you're leaving a big gap at the worst possible time. In the next episode, we'll pivot to financial decision-making and talk about powers of attorney, how they work, who to name, and why a generic form for the internet probably isn't good enough. In the meantime, if you're not sure whether you have a valid HIPAA authorization, or if you want to create one that works across Oregon's healthcare system, head over to tracktownlaw.com. You'll find the full blog post for this episode, along with an easy way to schedule a free consultation. We'll help you put the right documents in place so your people have the right access at the right time. Thanks for listening. I'm Jared Height from Tracktown Law, and this has been Passing the Baton.